yesterday with Mr. Kennedy Room for the first respondent.
Present, Your Honor.
I, Piero Lumumba, for the second respondent, assisted by Caroline Obure and Jemima Aduda.
This court are Robert John Ouko and Chris Philip. The ruling leads to the notice of motion application that was filed on 24th of August 2020. The same is supported by the affidavit sworn by number 72482, Sergeant Bashir Boya. The order sought as follows. Number one, that the matter be heard on priority basis, noting its urgency. Number two, that this honorable court be pleased to issue custodial order that the respondents hearing be detained for 14 days from today, that's yesterday, at Kilimani Police Station in Nairobi to allow number 72482, Sergeant Bashir Boya, a police officer and an investigator attached to Kilimani DCI, to complete investigations in a case of murder contrary to section 203 as read with section 204 of the Penal Code, which was reported at Kilimani Police Station by the OB number 0422082020. Number three, that this honorable court be pleased to issue such further orders that it may deem fit. Number four, that there be no order as to cause of this application. The application is further supported by grounds on the face of it, and the applicant's case is as follows. The applicant's case is set out in the grounds in support of the application, as well as the affidavit in support. The applicant deposed that the respondents were arrested on the 22nd of August 2020 following a report of a shooting incident at Galana Suites, Kilimani, and that the deceased was with the first respondent at this place of residence. Further, that a sound similar to a gunshot was heard from the deceased's bedroom, and the deceased was later pronounced dead at Nairobi Women Hospital, Hurlingham branch. A firearm was later recovered. The same is said to belong to the second respondent, who is a licensed firearm holder. The applicant seeks to have the respondents detained to allow for completion of investigations. He indicates that the statements are yet to be recorded from key witnesses, that is yet to take fingerprints, photo profiling, take respondents for DNA sampling, mental assessment, take the firearm to the ballistic expert, retrieve CCTV footage from the scene of crime. Further, that he is yet to do phone analysis and have the post-mortem done. The applicant's case was summed up by Mr. Mogere, Learned Prosecution Counsel for the State. The first respondent's case. Mr. Arum, Learned Counsel for the first respondent, opposed the application. He submitted that his client had the right to be released on bail and that he had cooperated with the police. That the first respondent was arrested after he presented himself to the police. But it has not been indicated that his client had interfered with the investigation. Mr. Arum insisted that the first respondent cannot interfere with what the police intend to do. Counsel submitted that there are no compelling reasons to have the first respondent denied his liberty. The second respondent's case. The case for the second respondent was argued by Mr. Lumumba, Ms. Obure, and Ms. Jemima Aluda, learned counsels. Mr. Lumumba submitted that the second respondent presented himself to Kilimani Police Station after hearing about the incident. The learned counsel submitted that The only mention about the second respondent is that he is the owner of the firearm that was allegedly used in commission of an offense. Further, that the second respondent cannot interfere with what the applicant intends to do as part of the investigations. He insisted that the police could have done those investigations if they wished to. Mr. Lumumba submitted that his client has been cooperative and will continue to cooperate. He lamented that 14 days is eternity. Counsel concluded by saying that the second respondent ought to be released on his own recognizance. Analysis and determination. Article